Well, we'd like to thank everybody for joining Carbon Law Group and Orsis Gate on this fine Wednesday. We are here to discuss fight, flight, or freeze, deals and disputes in the age of uncertainty. My name is Nabil Bisharat. I am a litigator at Orsis Gate LLP, and I'm joined by the fine folks at Carbon Law Group. Pankaj, Judy, do you guys want to introduce yourselves real quick?
Sure. So yeah, Nabil, thank you very much for the introduction and being the host here. My name is Pankaj Raval. I am the founder of Carbon Law Group. This is our second webinar we've done together, and I'm excited to be here. We're a transactional law firm based in Los Angeles, but servicing clients all over the world. And yeah, we're really excited to kind of talk about this, I think, timely topic today.
Yeah. Hi, everyone. My name is Judy Yen. I'm an associate attorney at Carbon Law Group. I work closely with Pankaj, and we handle a lot of business transaction and intellectual property matters.
Well, great. We want to thank everybody for joining us again. As we had said, the point of this entire webinar is for us to be able to focus on allowing you to ask us questions. Really, what we want is to make sure that if there are questions that you have, or if there are issues that have come up in your practice, that you get the chance to ask us. But otherwise, what we have been seeing is 4 or 5 months of just unprecedented uncertainty. A time when there has been increased business issues that companies have been facing, many of those problems being issues with contracts that they have had, business disputes that have popped up, and really the type of run-of-the-mill issues that you would expect to have, but heightened because of the fact that this uncertainty has continued, and it's continued much longer than many of us had expected that it would. We intentionally called this fight, flight, or freeze, mainly because so many businesses have been in that freeze state, meaning that what they have been doing is they've been set and they have been looking to see what is the best thing that they can do given this current uncertainty. And for many, what they chose to do was simply remain in place. That meant that whatever business agreements that they had, whatever contracts they had, they tended to just hold off on doing anything with them in the hopes that the pandemic would pass. That clearly hasn't happened. And so what we want to do is provide sort of two sides to this webinar. The first is that both Pankaj and I are going to discuss what we've been seeing from the transactional litigation standpoint. And then we want to use an actual lawsuit that was filed, one that was filed just recently that kind of highlights the types of contract disputes that we have been seeing, highlights the issues that you need to be aware of, and really pushes from our end what we want to see from you as clients, potential clients, or folks in the business community, so that you don't end up making the same kinds of mistakes, so that you understand how you want to move forward if litigation is inevitable, or on the back end, how to prevent that litigation from happening in the first place by simply structuring the deals the way that they need to be from the outset. So Pankaj, take it away.
Yeah, so thanks, Nabil, for that great introduction. Yeah, so we're really looking at this from two different perspectives too, as a transactional lawyer as well as a litigator, because I think those are two unique and important perspectives to have when doing any deal. A transactional attorney is going to approach it from the perspective of, hey, how do we protect the parties? How do we make sure that, well, first of all, most importantly, your client and my client is protected in the event something goes wrong. So, we oftentimes catastrophize what are the things that could go wrong, and a good lawyer will do that to a certain extent, while also making sure that we don't totally kill the deal, because oftentimes some lawyers will try to get a 50-page contract out there and make sure everything's covered, but in reality, that could actually just kill the deal as well. So it's a balance, and it's also an art in terms of doing it well. But as we'll see in the case that we're going to analyze later, VipShop, they did a terrible job. They, while they had a contract in place, the amount of ambiguity and the amount of issues that they missed with potential and easy issues, really, like things that most attorneys will say, hey, what happens in these situations? They didn't ask those essential and critical questions that I think could have saved them a lot of time and money and lawyers' fees. So, and there's a lot of really interesting issues that we're going to talk about in that case. But I think, one of the questions that, in thinking about this webinar, and Nabil and I had chatted about, hey, do people have this webinar fatigue? How do we make it useful to people? Because I'm sure you're all getting bombarded with webinar requests, and I do salute you and thank you for showing up here today, because I know everyone's busy, probably have kids and other things to manage at home, but we wanted to really just chat about like what has really changed. What are the things that have really changed practically in the world today? We live, on March 15th, we lived in a very, very different world than we're living in today. And what does that mean in the context of business and doing deals? And I think that's the backdrop of how we wanted to approach this. And just a little bit about that is that, from our perspective and our experience, when this pandemic hit, we scrambled as well. As a law firm, we're a business as well. We said, okay, let's get everyone going remote, and let's just see what we can do to make it happen. We didn't have a plan in place. No one really did, as to what to do in this situation. We just said, okay, everyone's working from home. Let's protect everyone's health. And that's the first most important thing. And then, interestingly enough, as a transactional firm, we started getting an influx of leads and clients reaching out to us for all different ways, asking for help with PPE deals. And this was a new area for us. We've done a lot of commercial transactions, in the sale of goods, but we were saying, oh my gosh, what's happening here? And people were reaching out to us from Spain, from China, from all over the world, America, saying, hey, I want to do these deals. There's an amazing opportunity. Help me make this happen quickly. And as a lawyer, you're saying, oh, quickly is a bit of a red flag, because oftentimes that means clients are willing to maybe cut some corners and maybe not do the proper due diligence that we recommend. And I realize there's a push and pull there sometimes as to the importance of getting a deal done, but also to make sure clients are making the right decisions. So with these PPE deals that we were seeing, we saw this one agreement that I think people found online from the International Commercial. Judy, what was the name of that company? The organization was? It was like some International Commercial Committee or something.
ICC.
ICC, yeah. And everyone was using these standard form, non-circumvention, non-compete agreements, and just signing them willy-nilly and not really understanding, okay, what are the effects? What's going to happen if actually someone does go around someone else to do a deal? And as a lawyer, that just gives us anxiety and heartburn, because there's so many things that are not being addressed, so many questions that are still there in the event that something does go wrong. We hate to put our clients in those positions. So one of the things that we really want to talk about today, and I think we'll get into more detail in the contract, is due diligence. Every deal, every transaction requires some amount of due diligence. So how is due diligence being affected today versus on March 15th? March 15th, you could maybe, if it was a bigger deal, maybe you could go fly to the client, you could go visit the client, you could have a conversation, you can meet in person, get to know them, really hash out the terms in person, and have that dynamic interaction and exchange. Now we're kind of, we're forced to use virtual methods of negotiating over the phone or Zoom, but it's changed, and the likelihood, and because we can't have that in-person interaction, there's, I think, a greater propensity to see more fraud. And we're going to see that in this case. And we experienced it too in our dealings with clients and them trying to deal with other clients. We having done this for a while, we have a pretty good smell test when we start talking to other parties and their level of sophistication. And there are so many unsophisticated parties trying to do these massive deals, $1 million deals. And we just gave us pause, to say the least, and something that we were really concerned about. So, understanding the likelihood of fraud, the likelihood that fraud is going to happen more often, and how do you protect yourself against that, is really important to think about in the context of doing these deals. Judy, do you have any thoughts about, what you've been seeing and the deals that you've been helping out with in regard to some of these transactions?
Yeah, so a lot of these transactions are extremely time sensitive, and we as lawyers will keep being pressured by these clients of getting things done quickly, and then sometimes they're not exactly sure what they need for this. It might be their first time doing these deals. They weren't people who were in the industry forever very well aware of what kind of legal protection they need. So within limited time frame was difficult to kind of really find out what protection they need. But with experience, I feel like it's a lot better for us now to know these kind of deals that only really like starting to appear after COVID, like what kind of protections these people will need. And because of the international nature of a lot of these deals, there were a lot of things that needs to be addressed with international business only that's not like seen in US business deals. I think that's also pretty unique for these PPE deals we've been seeing.
Absolutely, absolutely. Yeah, yeah. So I think those are some of the issues we've dealt with. I mean, are there any kind of questions about what we've been talking about so far, or anything anyone wanted to chime in terms of our attendees? Or Nabil, did you have anything you wanted to comment on there?
Well, absolutely. I mean, everything that you were just discussing now in terms of what we have been experiencing and what you have been seeing on the deal making front, we have been noticing and have been seeing from the litigation end. It's not just the PPE deals. It's not just the sort of COVID related contracts that we're seeing, but we're seeing it across the board. Companies, I think, in a rush to try and provide as much resourcing as they can to try and strike as many deals as they could, to get as much money as they could get in the door, given what was going on with COVID, tended to let the due diligence slip. And it wasn't just due diligence on the end of on sort of like the back end. It wasn't just, oh, does this deal make sense for us? It was, is this a true business partner, somebody that we really want to be in a business relationship with? And the result has been that the contracting themselves have gotten sloppy. The terms that have been in those agreements have been sloppy, and sort of thinking down the line as to what happens when a litigation does need to take place in order to enforce the agreement, what the provisions are that really give you the teeth needed to either enforce the agreement or defend in the event the agreement is not being fulfilled. And so what we have seen, I think, are two things. One, an over-reliance on these force majeure provisions, the hope that that will just be a catch-all that'll save everything, and they do not. And the second is a reluctance or a misunderstanding about what choice of law and choice of venue provisions really give you in an agreement. The governing law matters. Which contract, what state law or what nation's law applies makes a big difference. And if you don't have the right law in place, you are going to end up litigating possibly in a foreign jurisdiction or in another state where the laws are not as friendly to you. And it's surprised us how many contracts in the past few months we have seen pop up where those discussions have not taken place. So those are sort of the big things. The other big thing that we've seen is reluctance, I think, on a lot of companies' parts to understand that even though we are now living in this new normal of video depositions and video court appearances, there are still the normal costs associated with litigation. Depositions transcripts still need to be paid for. If you're choosing to arbitrate or mediate the case, you're still paying the arbitrator or mediator's company for their fees. You're still paying the arbitrator or the mediator for his or her fees. So these costs to litigate have not gone away. And they're not reduced necessarily just because everybody's using video conferencing software. So those have been sort of the big things. And I think as you have mentioned, the case example that we have really highlights just how sloppy some of the writing in contracts has become and sort of how bad the due diligence is. And so what I think we want to do now is sort of turn everyone's attention.
Nabil,
go ahead.
To the contract, I just want to kind of also, comment on one of the points you mentioned was regarding the what were called the standard terms, or sometimes general terms, or sometimes miscellaneous terms in contracts, right? A lot of people think these are just not throwaway, but just standard that you just whatever.
Boilerplate, you just toss them in. Yeah,
exactly, boilerplate. But those are actually really, really important terms when there's a dispute, and those should be negotiated, right? Those terms need to be understood as to, okay, even dispute resolution, right? What is the way we're going to agree if there is a dispute that we're going to resolve this? If it's an international transaction, is it going to be international arbitration? I mean, is it going to be arbitration in the United States? What's the arbitration body we're going to use? I mean, so, you know, those standard terms when you're looking at contracts should not be glossed over or glanced over. You know, those are really actually important terms when it comes to enforcing an agreement. And I just wanted to make sure that, you know, that was highlighted.
Absolutely. And everything you just said is absolutely correct. And really where it starts with is it doesn't start with me as the litigating attorney. It starts with folks like those at Carbon Law Group. It starts with those attorneys sitting down, drafting the agreements, and really meeting and speaking with the client to understand what the substance of the deals are supposed to be so that those terms make their way into the agreements. Again, what we have been seeing a lot of is corner cutting. And that corner cutting will hurt down the road, especially if you have not done the due diligence with the other party, if you don't know who you're actually getting into that contractual agreement with. And I think the case that we're going to go through real quick with all of those on the webinar today is an excellent example of that. So I'm going to switch this up. I'm going to share my screen so you can see this case. And you will see that the case itself is called Vipshop International Holdings. And Vipshop International Holdings was the plaintiff. Trans-Pacific Trade Center LLC and Kettipon, aka Kittipon, are the defendants. And what you'll see with this case, and you'll see there it was filed in the Northern District of Illinois, by way of some quick background, is the plaintiff, Vipshop, was a purchaser that was purchasing PPE equipment on behalf of one of the provincial governments in China. And the company that they identified to help supply that PPE equipment was Trans-Pacific Trade Center LLC, the owner of which is this individual named Ketty or Kitty Pon. Now that company, Trans-Pacific, is actually based in Illinois. And the agreement that they signed was an agreement that was written in both English and in Chinese. And it had several terms that were never really clearly defined. I mean, a lot of the terms that were outlined and the terms that were controlling were sort of vaguely written. And the agreement itself has both English and the Chinese text sort of meshed together on top of one another. And so when you read through it, you can see that what this agreement purports to be is a contract that is binding two different companies, each one in two different countries, to supply $2.5 million worth of PPE. But at the end of the day, when you actually kind of scrape away at some of the terms, you're going to see that what this effectively ended up becoming was a one-way arrangement in which Vipshop alleges it paid the entire amount that was owed on the agreement before they received any product, and in exchange, they got nothing. So what we're going to do is sort of scroll down this. You're going to see that a lot of the complaint itself is actually just sort of the general allegations that you might see, but there are a couple of things I wanted to highlight before we get to the substance of the complaint or of the contract itself. The first is that the allegation was that the defendant actually had a track record of spinning up shell companies, taking money from people to whom she promised to provide goods or services, and absconding with the money. That's a pretty layered accusation, but it does beg the question of why that history was not discovered in the due diligence process before the contract itself was signed, especially considering that, as you can see, this individual was actually sued in other cases just a couple of years prior to this contract. So another thing that we'd want to point out.
Actually, Nabil, I was going to just comment on that. And you know, and that's one thing we do as a firm is we have company investigator software as well as people investigator software for our due diligence. So, you know, inevitably those issues would have come up and been flagged. Whenever we do a deal, we always run these on the other parties because it shows the litigation, it shows liens against property, it shows lawsuits the individual has been involved with as well. So having someone or doing that, you know, trying to do that due diligence on your own as well initially is, I think, a critical first step in any of these deals in today's world.
Absolutely. And you'll see that it ended up creating a big problem for them later on down the road, especially because, as we have highlighted here, the defendants actually required that the plaintiff pay the full contract price up front. And this is the sort of term that usually would send bells and whistles screaming in any law firm's office, because typically what that ends up meaning then is that you've gone out of pocket fully and you have yet to receive anything. There's no way to do a background check on the product. There's no defense that's in place. So in a situation like this, what you need is for the agreement itself to really provide you an exit ramp or to provide remedies that are available to the person who's making these payments. And as will be seen, that really did not happen. So what we want to do is jump to the sales contract. And I'm actually going to kick it back over to Pankaj, because there are a couple of notes here that you'll see for things that are just bells and whistles that should have been going off, things that in a contract you're not expecting to see that you should be aware of, so that you make sure that you don't end up with an uncertain deal that you're then going to get stuck litigating in court.
Yeah, absolutely. And I think going off Nabil's last comment about the payment, payment in full is a huge red flag for transactional attorneys as well as litigators. When you see that term and without any assurances that there's going to be performance, once someone has your money, it's fairly common sense. Once you give someone your money, getting it back is a lot harder, right? So what we always recommend, and I recommend anyone who's doing any kind of substantial deals, is use an escrow service, or even we as lawyers have become something called a paymaster. We set up a separate trust account for our clients, and actually we serve as essentially an escrow for the clients if they don't want to use a traditional bank or other escrow service. So we are fiduciaries. It also can create we have to make sure there's conflict of interest waivers and all these things sometimes, but fundamentally we could help make sure that the funds are held and also only dispersed when there is performance by both parties. So having escrow, or like you have in real estate, or a paymaster as a law firm, is a really useful and easy step to prevent this exact issue from happening. But so that's just one of the things that they could have done differently, and would have saved them a lot of time and money that goes into this. Another thing that would have come up is we highlighted that the address for the defendant is her home address, and she has a Gmail address. Gmail is not indicative. It doesn't prove anything. But when you have someone who has a home address, who doesn't really have an office, and who's using a Gmail address, you wonder, okay, how much business is this person doing? How long has this person been around, where they don't want to go through the hassle of having a separate office, even a virtual office, and having a company website or anything like that. It's not indicative. It's by no means is that going to be an open and shut case, because you see these two issues arise in a contract. But it's a flag, and it's something worth looking into and questioning, just from our experience, because you want to be dealing with professionals in all contracts, and as just one of the things we noticed that would have also come up in our due diligence, and worth considering.
Yeah, and you'll see here. Oh, I'm sorry, Judy. Go ahead.
Yeah, sorry. I have a related comment to make about this. Is in a lot of these sale of good contracts, the parties will say what kind of entity they are and what state they belong to, and all these things are public records, and it could be confirmed, and we can see if the entity is in good standing or not. And if it's not, it definitely is a red flag as well that people in these transactions should notice and take note of.
That's a very good point, actually, Judy, you make, because one thing people don't realize sometimes is that if you have an LLC or a corporation and actually it's not in good standing and you do deals, those deals are voidable under law. So actually, the contract may be null and void. You may have no protections whatsoever if your entity, when you're doing a deal, is not in good standing, or the other party's entity is not in good standing. So that's one of the things you really want to make sure is looked into as well, because if you don't have an entity in good standing that's doing business, they really don't have the right to do business under that entity, and it may jeopardize the whole deal.
And those are all great points. Another red flag that we noted here was that the inspections before shipping, you'll notice here, were taking place in Beirut, which it raises the question of why the products and the goods were in Beirut to begin with, if they were either being manufactured by an American company. The product at issue here was supposed to be PPE manufactured by 3M. So it's either being manufactured in the United States or in one of their manufacturing plants elsewhere in the world. It might be that was in Lebanon, but it does beg the question of why there's this different port where these products are being inspected. given that the parties themselves are not Lebanese parties, and there's no reason, at least on the face of the agreement, for Lebanon to be the place where the product would be inspected before shipping for its ultimate destination in China. So that's, again, another one of these interesting issues that you would expect that there would be some discussion or some analysis as to why that is there. Another point that the folks at Carbon Law Group noted is this insurance provision. I don't know if you guys want to talk about this a bit.
Yeah, so insurance, again, this is a, you can say that, yes, insurance shall be covered by the seller and seller shall apply for insurance before shipping, but okay, what about the proof? What about providing proof of insurance before these goods are shipped? And maybe also it's good in the interest of the buyer to have insurance as well. Why not? Adequate insurance is really a helpful way to protect yourself in some of these deals, because if there is a problem, then at least you have some recourse maybe against your insurance company, unless they have a carve out. But I always suggest, if it's not cost prohibitive, insurance is a great additional protection that every client should be engaging in these larger transactions, because had they had insurance, maybe even the insurance company would cover their legal fees to go after them. So these are things that would have been worthwhile to look into, but again, it was a one sentence kind of provision in a contract that really has no teeth.
Exactly, and again, this goes to the point that we understand that this is an age of uncertainty. We understand that a lot of businesses are trying to strike deals and get those deals done as quickly as possible. But this is the kind of provision that in a normal contract would have been much longer. It would have included a lot of the details that Pankaj is talking about and would have provided, and more importantly, potential protections for both sides. Instead, there's just sort of this very shallow one sentence, one-off statement that provides protection really for no one. And in this particular instance, does not really help the buyer as needed. Another thing noted, again, just right here, this address for where payment would be sent, it's not matching the addresses where the defendants are supposed to be based. You have different addresses. It again begs the question as to why some of this stuff is not matching up. Those are concerns that, again, you'd want to be looking for. One of the things that was a red flag to me were these warranties. For example, this warranty, I quite literally do not understand what this is supposed to mean. Quality meets the national quality standards of the country of origin. Well, we haven't really defined what the country of origin is. Is it the origin for where the product has been manufactured? Is it the origin of the company itself? So for example, if we look at 3M, 3M is an American company. Is it American standards? Is it where those products might have been manufactured? So for example, the PPE may have been manufactured in China. Is it Chinese standards? And more specifically, what are the standards we're talking about? Are they manufacturing standards, shipping standards? Are they standards applicable to the use of plastics that might be in these products? Are there the metallurgical standards that apply? There are standards that we have in the United States, the ASTM standards. There are engineering standards that might be applicable, but usually that kind of information is provided in these warranties, or at least is laid out in the agreement, so you know that what you are getting is what you are buying is what you are getting, and what you are getting is properly certified for the uses that you want. Sort of these vague statements are not enough, and you need to make sure that all of that is really written out. And again, we would caution companies on moving forward with agreements because they like the dollar signs at the end. If these agreements and these warranties are not really in place, it will come back to hurt you in the end. There's more of this warranty language. I don't know if you want to kind of touch on some of this before we move on to the force majeure clause, because I've got a lot of comments on that, but I don't know if you have anything else to add there.
No, I mean, I think your comment is spot on. One thing I was just going to mention overall with these warranties is I think every provision in a contract needs to pass the so what test. As kind of I like to call it, is so what? So what does this mean? Like, so okay, what if it doesn't meet the standards? What happens in those situations? Trying to spell that out is very helpful in all these contracts, because otherwise you're left to common law or the law of the jurisdiction, or just bickering between the parties, lawyers going after, arguing back and forth, saying, okay, well, this didn't happen, and now what does that mean? What are the remedies? And if this doesn't happen? And I think that's really important with all these, the warranty section specifically, but also in general in a lot of sections of the contract. Okay, even a performance, let's say, there's a payment doesn't happen within a certain amount of days. What happens? Is the contract canceled? Is it, what are material breaches versus incidental breaches? And I think spelling that out in contracts is extremely important, extremely helpful. And you want your attorney or to discuss those issues with you, because, if you're just going into this agreement and hoping that it's going to work out, and you've never done a deal with this party before, you're really exposing yourself, and you're really going to be putting yourself in a detrimental position. So all these provisions, you need to ask, so what? What if this doesn't happen? And do we rescind the contract? Do we, what happens? And what's the method? What's the mechanics of unwinding this potentially?
Absolutely. And I think that the points that you just made are so important with respect to the paragraph 11 there that you see, the force majeure clause. And the reason for it is sort of as a blanket, sort of black letter legal issue. You have to remember that judges, courts, arbitrators, mediators, whoever the party is that's adjudicating the claim that might eventually occur in litigation, is looking at the language of the agreement as the starting point. They are not looking to rewrite the contract to sort of match what the parties were thinking or what they meant, or, we talked about this on the phone and this should have said that, and that's kind of what we were thinking. The starting point is, does the contract's language provide you the standard that you are requesting, the remedies that you are requesting, the performance that you are requesting? Is that in the language of the agreement? If it's not, then trying to prove that that's what was supposed to be there, or trying to explain what vague or uncertain terms means, can become a very costly, expensive, and ultimately uncertain thing that will be difficult to do on the back end again. So do not rely on the fact that you had a telephone call, or don't rely on the fact that there's an email somewhere that you think maybe clarifies what these points mean. Get that language in the agreement. And that's especially important for these force majeure clauses. You'll see this first sentence just says, in case of force majeure, the seller cannot, in whole or in part, ship or delay the shipment of the contract goods. The seller shall not be held the responsibility. So not only is the translation off, but you have this sort of concept of force majeure without any definition of what force majeure is. And it's important to recognize that force majeure, you don't just put the phrase into a contract and then suddenly it has meaning. Instead, what you need is to define what a force majeure event is. Is it war? Is it a terrorist attack? Is it, like we're experiencing now, a pandemic? What qualifies as a force majeure event? Because not every jurisdiction has some statutory language that can be invoked to define what that means. California does have a statute that does give some backing to an act of God or a force majeure, but outside of that, courts are going to look at the language in the agreement and say, did you qualify this? Did you define it? And here they did not. Instead, they have sort of this awkward language at the end that says, if the above mentioned accident lasts for more than 7 days, the buyer has the right to rescind the contract and shall not be held responsible for the accident. Again, accident is this broad, vague term. Anything could qualify as an accident. It could be a car accident. It could be a boating accident. It could be something that happens at sea, or it could be something like this pandemic where it comes in, it is considered to be a force majeure event, and it's impossible now for us to be able to spread the PPE around or send it, in the case of this contract, to the party that's making the purchase. The point is that a provision like this effectively means everything and nothing all at the same time. And it's read confusingly precisely because the parties didn't really sit down to hammer out what concepts would actually be qualified as force majeure, which is crazy when you consider the fact that they are agreeing and writing this contract in the middle of a pandemic. So you would assume that they would take the time to make sure that pandemic-related freezes on transportation or shipping or border closures or any number of these things would be considered part of the force majeure clause, but they didn't do that. They didn't contemplate it. And as a result, what you are seeing now is a force majeure clause that probably doesn't have any real teeth from the buyer's perspective. It doesn't actually afford them any protection. So invoking this right to rescind, it may not actually happen under this force majeure clause, precisely because those definitions were not put into place.
Judy, do you have anything to comment on that?
Yeah, I have a comment to make about that. I think the reason why that provision looks like that potentially is because it was the Chinese speaking party that proposed this agreement, and it's the English version was the translation of what the Chinese version was. And in these international deals, we need to be aware that legal systems are different from country to country. And China is like a civil law country, and contracts agreements in civil law countries tend to be a lot shorter, kind of like that. And for American lawyers like us, it wouldn't really make sense. We will see all these things in the bill mentioned as missing. But in a civil law country, maybe there are laws that, most likely there are laws that already address these issues. And in this specific contract, actually it's stated later that Chinese law governs. But I feel like for the buyer, when they're looking at this contract, they probably were only looking at the English part, and they weren't really thinking about what kind of effect this language actually, protection this language actually gives them. It actually gives them nothing, or whatever the Chinese law says, they are not aware about that.
Yeah, and again, remember, this is a lawsuit that got filed in the Federal Northern District Court in Illinois, right? So you are now sort of in this weird situation where, as Judy mentioned, and as you'll see later on in this paragraph 14 that you can see on your screen there, where it's talking about arbitration, it is true that we're supposed to be governing this contract under the laws of China, but you're now asking an American court sitting in Illinois to effectively be the party to enforce those laws. And there's no real context provided. In the complaint, there's no context provided for it. And even notwithstanding that, I agree. I think that what was likely happening was that the parties were probably looking more at the English translation, even though the agreement does later on say that if there is a difference between the two, the Chinese version prevails. So you have all of these issues that pop up. And again, this is not just limited to this specific issue. I can provide a great example of this. We were contacted by a company that was manufacturing hand sanitizer in Mexico. As many of you might be aware, there was a massive recall by the FDA for dozens and dozens of hand sanitizer products because they were finding that somewhere in the supply chain, the manufacturers were purchasing alcohol that contained too much methanol in it, and it was illegal to sell that in the United States. Well, if you take a look at some of the agreements that were struck, oftentimes the agreements were either under Mexican law, or there was no venue provision that was provided, or in some circumstances, there wasn't even anything in writing. You just had sort of these vague emails that went back and forth without like a true, genuine contract in place. So you have to know what rules are going to be applicable. And it's especially important when you have something like this arbitration provision, where you're now suddenly using a foreign jurisdiction's law in a foreign arbitral court. And the way that those arbitrations take place may be very different, very, very different than what you would expect from an American arbitration sitting in any one of the 50 states here, or even in an arbitration that is being arbitrated through one of the international arbitral associations. This is sort of the trickiness that comes with negotiating these agreements on an international level. And it's especially important to know that you're dealing with counsel before signing these agreements to make sure that you are covered. I don't know if the folks at Carbon have any other information or any other thoughts on that, but that really stood out to me as being a big, big deal.
Absolutely. Nabil, I was going to mention too that, like, I mean, from a litigation standpoint, if Kitty Pon, the defendant is represented by counsel, inevitably one of the motions they'd bring is to say that this is the wrong venue.
Absolutely. Correct? Yes. And then this case would have to go away. And it's possible that motion may have been subsequently filed. This case was filed about 3 months ago. So it is possible that something like that happened. And if it did, odds are the court, I mean, this provision is not that confusing, assuming that the translation, because it is the Chinese version that governs, matches what is here in English. That's a pretty, say it one more time.
Yeah, it matches. I read them. Yeah.
So there you go, right? So, I mean, that's pretty specific. I mean, that in and of itself, unfortunately, would lead a judge to say, I don't have jurisdiction. You agreed to arbitrate this under the United Nations Convention on International Sales of Goods and the International Court of Arbitration. Please leave my court.
Yeah, so I was going to ask Nabil like you about this, because I think it's a question that comes up from a lot of clients, and maybe here today is like, is there a preference? Is it better to have an arbitration provision like this versus a jury trial provision?
Yeah.
What are your thoughts there?
So I've got a couple things, and I don't want to eat up too much more time here in case there are any questions. But I will say this: you really need to take a step back and think to yourself, what are the benefits of having an arbitration be a dispute resolution mechanism versus just a court? Many times people pick arbitration because for one of two reasons. One, they might be dealing with sensitive information and they want a private process, one that is not public in the courts. Or two, the party that's pushing for the arbitration provision believes that it would be beneficial, maybe to put their weight on the scales to make the parties pay for the arbitration. Because you have to remember, arbitration, you're paying for it. You're paying for the association, and you're paying for the judge or the arbitrator's time. And that time might be split between the parties, but it can be expensive. You're talking about folks who might be commanding $700, $800, $900 per hour to arbitrate these cases. So you're paying for not only your lawyer, but also the arbitrator's time. So, you need to ask yourself what the purpose, what the point of having an arbitration provision in there might be. The benefit of arbitration is that it does afford typically a more streamlined, efficient, faster process. COVID has had a demonstrable effect on the courts. It has, especially at the state court level, it has slowed down civil litigation to the point where there is a massive backlog in the California state system, and in particular in Los Angeles. The courts are trying to move through them. You're not necessarily getting a jury trial like you're used to seeing on television, right? Because you can't stick 12 people randomly in a jury box anymore. Those things are now the courts are trying to work out how do you do that remotely. So you will have jurors maybe sitting at home watching this through some kind of Zoom or web-based application. The courts are rolling them out, but they're rolling them out slowly. Arbitration does usually provide, it's not going to be a jury trial. There's no jury in an arbitration. And it's going to be much more efficient, and we'll still probably be utilizing those technologies to try and get the deal done. So there's a lot that goes into it. And I would advise anybody that might be contemplating sticking a dispute mechanism like arbitration into the agreement, that they speak with litigation counsel, or at least talk to their attorneys to figure out if it makes economic sense to use arbitration versus just relying on the courts.
Thank you. Yeah, no, it's a great answer, and yeah, thanks for that insight, because it comes up a lot, and I think something that we discuss with clients a lot is what's better. Is it better to, and there is no real right answer, right, to that. It was a bit of a loaded question because it really depends on what what you're trying to accomplish and what the concerns and risks are. So a lot of these issues do need to be weighed and considered. There is no real just default in a lot of these terms.
So, I mean, those are just sort of some of the points we wanted to draw out. I mean, I'm sure if we really wanted to spend another hour on this, we probably could, but those were some of the big points. I don't know if there's anything else that you guys would like to go over, Judy or Pankaj, if there's anything else that you think might be worth highlighting in this. But I mean, those were the big things that I think stood out to the three of us rather, when we were reviewing this, as issues that really you should be confronting. And again, we understand companies are feeling a lot of pressure. You want to get the deal done, but this matters. You really need to get this right, because if you don't, as you've seen with this case, you're going to be paying for it on the back end.
Absolutely. Yeah, I agree. I think I think these are definitely a lot of the major issues. We didn't even get into the miscellaneous or standard terms that we were talking about earlier on, but but some of these, arbitration is sometimes a standard miscellaneous term that is included, but some of these are, they're not. There's a lot of issues here. With this contract overall, when you have capitalized terms that are not always defined properly. When you don't have proper integration clauses, these are all issues that we could definitely talk about at length for another hour or two. But we want to be conscious of everyone's time here. So, I know, Judy, did you have anything else to comment on for the contract overall?
Yeah, I think a lesson we can learn from this case is that, we've been seeing a lot of this in deals like this, time-sensitive deals like this. There's a strong imbalance of negotiation power between the buyers and sellers, because these goods are in such high demand, the seller have a lot of leverage. And as we see in this contract, that a lot of the terms were drafted strongly in favor of the seller. And it's odd as attorneys that we're looking at this like, why would a buyer's attorney not advise their clients to not agree to these terms? And I think a lesson we should take away from this case is that it's not worth it to rush into deals like this, because you will end up in a situation like this, paying the buyer all the money and not getting anything you were supposed to get from the buyer.
Which could create additional liability. Yeah.
Exactly.
So yeah, I know we have a couple of participants today, but Marcus, Fan, did you guys have any questions for us, or anything we wanted to chat about?
I've got one. Nice to see you, Pankaj.
Thanks for joining.
I was sort of thinking about like force majeure provisions for like contracts that were already executed prior to the pandemic, in particular for like contracts that apply to the media and entertainment industry. I just want to get your thoughts on that.
Sure. So I don't know.
Yeah.
Do you want?
Please.
You want to go?
Nabil, go ahead.
Sure. So the starting point is what law is in place that governs those. I mean, typically I would assume it's probably California, right? If it's a media entertainment thing. And if so, there is a statute. There are statutes in California that do provide sort of some baseline cover for what might be considered a force majeure event that would allow you to excuse performance. But analyzing that and really kind of executing and moving forward with saying, okay, I'm going to excuse the performance under this agreement really does require taking a very close look, first off, at any of the other provisions in the agreement. There might be warranties. There might be an excuse for performance provision. There might be some other provisions within the agreement that sort of carve out what is effectively force majeure, but just not explicitly stated as force majeure. So you've really got to take a very close look at that. Presuming that there's really nothing that kind of covers that. The next step would be to say, okay, California has statutes in place that do allow for the excuse of performance. Does COVID apply? And their courts do typically take a very, I don't want to say they take a myopic view because that's probably a little too strict, but they do take a very narrow view. They're going to look very closely and they're going to say, okay, what is the performance required? If performance, for example, is simply you cutting a check and putting that in the mail and sending it, that doesn't necessarily mean that performance can't be excused, right? You could still do that. COVID does not prevent that. But if the argument is that the underlying rationale for the agreement, the purpose of the contract has been effectively eliminated by COVID, then you could be making an argument that the impossibility doctrine has kicked in and it's no longer worthwhile, or that it has been rendered impossible for this agreement to really take place, or the performance or the purpose of it has been rendered null and void, in which case you'd be making that argument, but then you wouldn't really be relying on anything in the contract. You'd be sort of putting up your hand and hoping that the judge picks you and says, okay, I get it. I get the reason why performance is impossible to perform here. What we have been seeing sort of as a trend is that in a lot of different industries, entertainment being a big one, but also hospitality, right? Hotels, car rentals, all sorts of things, anything related to travel and hospitality. Courts have been varying as to whether or not there really is rationale to undermine the core of the agreement. What we have been advising folks on doing is saying, if you're in a position where you have an agreement, there is no force majeure provision, it isn't defined, and you're really just trying to get out of the contract because the purpose of the agreement has now been rendered void, you really want to try and see if you can't negotiate with the other side before you take a chance with the courts. We touched on this in the webinar we did a couple of months ago. The case law on this, a lot of it is coming out from like the 1910s and 20s around the Spanish flu. There's some stuff that came out right around World War II. And then there's just sort of this dearth of case law. There's very little that really kind of creates this robust body of law that would provide you, dozens of examples to rely on. Primarily because we're dealing with something that's sort of a once in a lifetime, right? So the case law follows accordingly. So, I say that there's a lot that's there. And what I would really recommend is that if this is a situation that has popped up, that you speak with counsel and see if you can get some creativity going as to how you might be able to back out of the agreement or enforce it on the other end. But yeah, that's sort of a long answer, but there you go. It's kind of a complicated issue.
Absolutely. Yeah, I would agree. I mean, I think the bill summed it up very well. Those are the issues I think you do need to address and look at, not just the force majeure, but also, the rest of the contract and other statutory issues, and defenses potentially involved. So really also, yeah, it depends on what side of the deal you're on as well, of course.
Exactly. Yeah.
So.
Okay. Well, I mean, unless there's any other questions or comments, I think we've run our course. Judy, any other thoughts or comments?
I think muted.
Oh, I think you're on mute.
Sorry, yeah, no.
Okay.
Okay, perfect. In that case, thank you to everybody who's attended, those who are attending both live and who are just on view mode. We appreciate you being in attendance for this. Be on the lookout for any future webinars that we happen to do. As you can see, both OrsaScape and Carbon Law Group have been focused as best as we can on every issue that has been popping up during the pandemic. There has been a lot that has been there. I know that we've seen and heard from a lot of clients and potential clients about the problems they're facing. I know Carbon Law Group has done the same. And so we will continue to try and bring you as much information as we can and as efficiently as we can. And if you guys have any other questions or comments, feel free to reach out to any of us. I think everyone's probably got our contact information by now, so you're welcome to reach out. So on behalf of OrsaScape, thank you so much. We look forward to seeing you at our next webinar. I'll kick it over to the folks at Carbon Law Group to sign us off.
All right. Thanks a lot, Nabil, for hosting this. And yeah, thank you all again very much for joining. I know your time is precious, and we really hope that you got some value out of this. You learned a little bit something today about contracts and some of these issues that we're dealing with in this age of uncertainty. If you do want to hear more, or if you have any specific requests for webinars you'd love to discuss in the future or have us host in the future, please let us know. We're always available. We'll probably send out our information, and I'll put it actually in the chat right now too, just so if you guys want to get a hold of us. But yeah, we really appreciate you guys attending today, and hope it was worthwhile. And we always welcome feedback if we can always improve in any way. Thank you.
Thanks again.